Labor and Industrial Law by MG Law. Now we will start Industrial Disputes Act 1947. In it we will cover industrial dispute, page number 13. Industrial dispute. Okay, so what is the definition of industrial dispute? According to section 2K of Industrial Disputes Act 1947, any dispute or difference between employers and workmen, or employers, or between workmen and workmen. Okay, any dispute between them or any difference between them, and that dispute or difference should be connected with the employment or non-employment, or the terms or rules of employment, or the conditions or requirements of labor of any person. If these dispute or difference is connected with these points, okay, then it's called an industrial dispute. So this was the definition. When does industrial dispute arise? Industrial dispute arise only when a demand is made by workmen and it is rejected by the management. Okay, then an industrial dispute will arise, or vice versa. It means demand is made by management and that demand is rejected by workmen or workers. Okay, then also industrial dispute will arise. Then case laws. In Star Paper Mills versus Industrial Tribunal, it was said that if demand by workmen is accepted by employer and workmen are satisfied, then no industrial dispute will ever come into existence. Okay. Next case, in Village Papers Private Limited versus Himachal Pradesh, it was said that if demand is not communicated to the management, then no industrial dispute will arise. Okay, if the demand is not communicated, if the management is not aware of the demand, then how the management can accept or reject that demand? Okay, so there will be no industrial dispute. Is a dispute between a single workman and his employer an industrial dispute? Before section 2A was inserted by Act 35 of 1965, okay, before this section was inserted, an individual dispute was not an industrial dispute. For an individual dispute to be an industrial dispute, either it should affect the interests of workmen as a class. Okay, it was said in Newspapers Limited versus Industrial Tribunal, Uttar Pradesh, or the individual dispute should be taken up by the trade union and the demand by workmen for its redress or solution. Okay, it was said in Indian Oxygen Limited versus workmen. Or the dispute should be, the individual dispute should be supported by substantial number of employees. Okay, so this was said in CP Transport Service versus R Gopal Patwardhan. But after section 2A was inserted, the individual dispute also came into the category of industrial dispute if the individual dispute complies with the requirements of section 2A. Is a dispute between a dismissed employee and his employer an industrial dispute? After section 2A was inserted, yes, if it complies with section 2A's requirements. It was said in Chemical and Fibers of India Limited versus DB Behr case. So in what conditions an individual dispute becomes an industrial dispute? Either it is sponsored by trade union, okay, then it will become an industrial dispute, or the individual dispute, if it is not sponsored by the trade union, then it should be supported by the majority, okay, then it will become an industrial dispute. Or the individual, if the individual dispute complies with the requirements of section 2A, then also it will become an industrial dispute. So this was industrial dispute. First we saw the definition. It was said that an industrial dispute is any dispute or difference between these employers workmen, employer employers, and workmen workmen. If this dispute or difference is connected with these points, means employment, non-employment, or terms of employment, or conditions of labor of any person, then it's called an industrial dispute. When does industrial dispute arise? Only when, if demand is made by workman and rejected by management, or demand is made by management and rejected by workman. Okay, in these conditions, an industrial dispute arises. We saw two case laws. One was Star Paper Mills versus Industrial Tribunal. In it, it was said that if demand is made by workmen and accepted by employer, and the workmen are satisfied, then no industrial dispute will ever come into existence. Or other case was Village Papers Private Limited versus Himachal Pradesh. In it, it was said that if demand not communicated to the management, then no industrial dispute will arise. There was a question like, is a dispute between a single workman and his employer an industrial dispute? So before section 2a was inserted, the individual dispute was not an industrial dispute. After section 2a was inserted, it became an industrial dispute if it complies with the conditions of section 2a. Okay, before insertion of section 2a, for an individual dispute to be an industrial dispute, either it affects the interests of workmen as a class, or the individual dispute is taken up by the trade union and demand by workmen for its redress, then it becomes an industrial dispute. Or the individual dispute is supported by substantial number of employees, majority of employees, then it becomes an industrial dispute. After section 2 inserted, yes, the individual dispute becomes an industrial dispute if it complies with the requirements of section 2a. Is dispute between dismissed employee and his employer an industrial dispute? After section 2a was inserted, yes, if it complies with the requirements of section 2a. When an individual dispute becomes industrial dispute, so we saw that if it is sponsored by the trade union, if not sponsored by trade union, then by supported by majority, or if it complies with the requirements of section 2a. So this was industrial dispute. If you want the PDF of these notes of industrial and labor law for revision, then you can get the link in the description or the comment box. You can get from there if you are interested. Next topic we will cover is objects of Industrial Disputes Act. This we will see in next video.